State Board of Retirement versus John Bulger.
Ms. Lee? You may proceed.
Good morning, Your Honors. May it please the Court, Grace Lee, Deputy Treasurer, General Counsel to State Treasurer Tim Cahill, on behalf of the State Board of Retirement. And with me is the Executive Director of the State Board of Retirement, Nick Favorito, Your Honor. Your Honor, the single issue before this Court is whether the lower court substantially erred when it ruled that Mr. Bulger's convictions for perjury and obstruction of justice did not involve violations of the laws applicable to his office. Boiled down to its essence, this case is about whether a clerk magistrate can administer the oath in one courtroom and violate that same oath that he administers in another courtroom and still be entitled to a pension under Chapter 32. And the answer to that question is no, pursuant to the statutory language of Section 15.4 and this Court's decisions in Gaffney as well as in McLean.
Part of your argument, Ms. Lee, if I understand it, is that the plaintiff's, Mr. Bulger's official duties forbade him from lying to the grand jury. Is that right?
No, Your Honor. Pursuant to the statute, the statutory language requires that there be a conviction, that conviction involve violations of laws. Which laws? Those laws that are applicable to the position or office, that of clerk magistrate. So it necessitates an examination of the laws that surround the office of clerk magistrate.
But what I'm getting at is, isn't everybody forbidden to lie to the grand jury? Why is it any different because he's a clerk magistrate?
Oh, absolutely, Your Honor.
So why does it relate to his official duties? And no one is supposed to. It's
Absolutely.
a violation of law for anyone to lie to the grand jury.
It's abhorrent for anyone to lie, Your Honor. However,
it's not only abhorrent, it's illegal.
Absolutely.
Well, what you're saying is it's a little more serious for someone who's charged with a fairly high judicial position to lie to a federal grand jury. It would be quite a different thing if he was, for example, a snowplow operator who lied to the federal grand jury.
Absolutely.
There'd be no connection then, no nexus between the job and the perjury.
Absolutely, Your Honor. And I think the distinction is when looking at the laws that surround a particular position, whether it's a clerk magistrate or a snowplower working for the state, the laws that govern that particular position are those that are applicable to his office, and that's what we're looking at under Section 15.4.
On the other hand, he served for 32 years, did
Indeed.
he not? And it is rather harsh, isn't it, to take away a pension from someone who worked 32 years?
Absolutely, Your Honor. However, as this Court recognized in Gaffney, Section 15.4 holds an intermediary level of severity in contrast to Section 3A, where the accumulated deductions and pension allowances are forfeited. Section 15.4 affords the member the opportunity, it entitles the member to take back their accumulated deductions. What it doesn't allow...
That's the contributory portion?
Yes, they get what they put into the system. What they're not entitled to is a pension allowance that's subsidized by the citizens of the Commonwealth. And the reason why it's tempered in contrast to Section 3A is because, as this Court recognized in Gaffney, the legislative intent was to broaden the reach of criminal offenses that would trigger a pension forfeiture. However, with that being said, in the context of the Gaffney decision, this Court also tempered that broad scope by giving a framework for the boards to analyze Section 15.4. However, it doesn't preclude the statutory language of Section 15.4 being applied, which is a conviction, whether that conviction involves violations of laws, which laws, the laws that are applicable to that office. In this particular case,
I take it you would consider it of no relevance that this involved a family situation? A brother, two brothers?
absolutely. Your Honor, it's absolutely not relevant to the extent that the board has to apply the statutory standard of Section 15.4. As this Court noted, the pension forfeiture is automatic. The motives are absolutely irrelevant. To the extent that the legislature drafted Section 15.4, the board has to apply it.
You know, in your brief, you rely fairly heavily on Massachusetts Bar Association versus Cronin, which has some very persuasive language as to why someone in a clerk magistrate's position should not continue in that position if they are, in fact, guilty of perjury. But I note this other language in that case. And in that case, this was a clerk magistrate who committed perjury in connection with an investigation into something that had nothing to do with the clerk magistrate's office. And the Court said that this testimony had no relation to his duties as clerk is not of consequence when it came to his removal. But isn't it of consequence under this statute? Doesn't Gaffney say specifically that only those violations related to the member's official capacity are targeted?
Yes, Your Honor, and it's not relevant to the substance of the testimony being related to the official position is not relevant to the extent that the statute specifically gives three elements. And in Gaffney, the purpose of Gaffney was, as this Court knows, was that Section 15.4 does have a penal aspect, which is why the statute needs to be interpreted narrowly. That does not preclude the elimination of some vocabulary in the statute. The statute still has to be interpreted, and the instruction of this Court in Gaffney was to interpret that statute very, very strictly. The literal interpretation of that statute necessitates, again, a conviction involving a violation of law, which laws, his oath of office, the code of conduct, his canons, as you will, as well as his duties and responsibilities under Chapter 219.
Now, the oath is important, is it not? All judicial officials take an oath to uphold the laws of the Commonwealth and the laws of the United States, Constitution and laws of the United States, do they not?
Yes, they do, Your Honor.
And this is a clear violation of the latter.
Yes, Your Honor. As well as the canons.
The Code of Professional Conduct.
Absolutely. It's Canon, I believe it's Canon 2 specifically states that a clerk magistrate will uphold the laws of the Commonwealth as well as the laws of the court.
But that leads to a fairly ridiculous result, because then the violation of any law, any criminal law, would automatically result in the loss of a pension. And that, you certainly don't argue that's the case.
Absolutely not, Your Honor.
But we're sworn to uphold the law.
Indeed, Your Honor. And I think that's where this Court's decision in Gaffney is truly, truly instructive. To the extent that this Court recognized it's only those violations that are related to the official capacity of the office, that is where that analysis needs to be implemented at that step. And looking at the offense of perjury and obstruction of justice, one cannot escape the conclusion that the two are inextricably intertwined. In every action...
I keep going back to Gaffney. You're right. Gaffney is a very important case interpreting the statute. It says the touchstone is criminal activity connected with the office. How is this criminal activity connected with the office of clerk magistrate of the particular court?
Your Honor, it's connected directly to the office of clerk magistrate because with every act a clerk magistrate executes, and whether it's filing, setting bail, issuing a summons, conducting hearings, conducting pretrial hearings, issuing probable cause for a complaint to go forward, a fundamental premise that in every act begins and ends with the facilitation of truth and justice. Once those fundamental tenets are extracted from that particular role, that clerk magistrate is left impotent to perform any task, because every task requires those fundamental tenets.
But please separate this out in your mind, if you will. There may be very good reason why a clerk magistrate who has committed perjury should be removed. In fact, if he's sentenced to federal prison, I think he is removed. I mean, there are and certainly Cronin says, absolutely, you can't have a clerk of court cloaked with all of these important functions, continuing to operate, having committed perjury. All right? I mean, that's what Cronin says. But we're not talking about removal now. We're really talking about the pension statute, which I think is far more narrowly drawn.
Your Honor, and I'm sorry if I didn't make this more clear in my brief. Cronin just articulates one and helps in looking at the case and the facts and circumstances around this case. Cronin just highlights it's a consideration in determining whether the laws applicable to Mr. Bulger as a clerk magistrate's position were violated. In looking at it in its entirety, the laws that govern his position, as well as the case law established by this court, it becomes abundantly clear that indeed those laws have been violated.
I take it, Ms. Lee, that one way that the legislature could have written the statute, in no event shall any member after final conviction of a criminal offense arising in connection with the execution of the official's acts. It didn't do that, correct?
Absolutely, Your Honor.
In other words, Gaffney is helpful, but Gaffney also had a fact pattern where there is an employee, there's larceny, but the employee was a superintendent who happened to have responsibility over that. It is not at all clear to me, for example, what would happen if one had, a serious theft of, let's say, the secretary to the chief financial officer of the Supreme Judicial Court. Right? We don't have that case.
No.
Correct.
That's correct, Your Honor.
And so what we look at is the laws applicable to, and if there are no laws applicable to, I don't know what the laws applicable to means in the context of Kurt Gaffney, but because what the court seemed to be saying was he had some administrative responsibility, and I suspect that that's why the court was going to say the touchstone is the activity connected with the office or the position. One could argue that that language is not consistent with the statutory language.
Yes, Your Honor, one could argue that, and however, the Board is not advocating that position. I think,
No, of course not, because we've got a different kind of case.
Absolutely, Your Honor. And I think that it's abundantly clear based on the statutory language of Section 15.4, and for lack of a better characterization, Gaffney tries and it did successfully reach the misconduct in office component. And indeed, that is included in the interpretation of Section 15.4. However, it does not preclude the application of the statute, which specifically requires that a violation of the laws applicable to that particular position or office.
In fact, as you know, in Gaffney said, excuse me, it doesn't apply to me because then I didn't violate any of the laws applicable to my office. That was the narrow piece.
Absolutely.
And the court said, it's laws applicable, but we take a broader reading, which is, it can also be the activity connected with the position, correct?
That's absolutely correct.
I mean, the court didn't say it doesn't cover laws applicable to your office.
I absolutely agree with you.
And it is also the case the Supreme Judicial Court was trying to interpret a statute in the wake of the
Collados decision.
Well, the legislature saying you got it wrong.
Absolutely, Your Honor. And I think that's underscored by, although McLean didn't address this issue of whether the violation of the laws were applicable to the office, I think McLean is a more clean example of the application of Section 15.4, because in McLean, the senator violated subsection 7 of the state ethics statute, And as a result of the violation of the state ethics, criminal violation of the state ethics statute, it was the most narrow application of Section 15.4 because you automatically had the conviction as well as the laws applicable to the office being the one and the same. However, in reading the statute doesn't necessitate that. In fact, if you look at the statute, it contemplates that it says criminal convictions involving violations of laws, plural. The plural obviously expressly contemplates that there are other laws, there may be civil laws that are applicable to the office and position that that particular member could violate that would trigger a pension forfeiture, assuming that the nexus with the criminal conviction and the violation of laws and the official capacity of clerk magistrate in this particular case is satisfied.
Let me get back to one of the hypotheticals that Chief Justice was referring to. Some of the laws that are applicable to the office of the clerk are the criminal laws, just the general body of criminal laws. And clerks are issuing arrest warrants, they're issuing complaints, they issue search warrants. If a clerk magistrate is convicted and sentenced to jail for because he or she has drugs in their home, I take it if they're in jail, they would be removed from their position as clerk magistrate. But does that necessarily mean that they also forfeit their pension?
Your Honor, I can't speak to what a board may or may not do, but to the extent that I can hypothesize in determining whether those criminal convictions are related to the office or position, one can hypothesize, even if he wasn't removed, that in all drug-related offenses he could recuse himself and he could refrain from participating in any type of drug-related offense, thereby still being effective in the context of assault and batteries, domestic violence, shoplifting, and a Pandora box of activities that a clerk magistrate ordinarily conducts. However, with the offenses and convictions of perjury and obstruction of justice, that remedy is just not available. As I sound like a broken record, but the convictions of perjury and obstruction of justice and the position of clerk magistrate are inextricably intertwined, and they cannot be separated. I see that. Thank you, Your Honor.
Mr. Hines.
Good morning, Your Honors. The facts of this case demonstrate why the pension forfeiture statute needs to be strictly construed and why retirement board decisions cannot be influenced by emotion or by publicity. The questions that are put forth to the board demonstrate that there needs to be the direct link in Gaffney. The board in this case is ignoring your decision in Gaffney and asking you to judicially amend the statute by ignoring the limiting language in 15.4 applicable to one's office.
Can I ask you this, though? I mean, here we have a federal grand jury, and so we have a violation of federal law, violations of federal law. What if this were a state grand jury, and Mr. Bulger pled guilty to committing perjury before a state grand jury involving a criminal investigation in this state? Does that make a difference?
No, Your Honor. And what it would make a difference, obviously, as the Cronin case discussed, and I think that's where the board confuses the issues here. This is not a termination case. And you'll see in the administrative record, immediately after they suspended Mr. Bulger's pension without a hearing, they then conducted a hearing, and they framed the issue. The hearing officer in that case framed the issue is termination would result in pension forfeiture, and that is simply not the case. No doubt, Mr. Bulger did withhold information from the grand jury. He pled guilty. He accepted responsibility for his actions. It was a personal matter. It was based in family loyalty. It did not involve...
Mr. Hines, may I ask you this, because we don't look to the motives. As far as I can understand, okay, the board has said has pointed to the oath of office of the clerk magistrate and the code, specifically SJC rules 312 and 313. Are those laws, first of all, are those laws applicable to the office of clerk magistrate?
Your Honor, the SJC rule may have the force and effect of law, but they're not the laws that are not in the context of pension forfeiture.
Wait a minute. Are they laws applicable to the office, either the oath or the rules?
Your Honor, I don't want to pass words, but in terms of pension forfeiture, which this Court has said in both Kalatis and in Gaffney, it's penal in nature, and it is subject to a strict construction, notwithstanding the Board's argument of a broad construction.
And it's also a broad phrase. So your answer is no.
Because
your
correct,
answer
Your Honor,
is no.
Because if you do, in the context of pension forfeiture, then any violation, any
No. We're not going to any other. I'm talking about clerk magistrates, and I'm looking to what the Board pointed to. The Board pointed to the oath of office and the Supreme Judicial Court rules, correct? That's what the Board pointed to. Laws applicable to.
Correct, Your Honor.
Okay. So you say no within the meaning of the statute. These are not laws applicable to the office of clerk magistrate.
And I'll explain why, Your Honor.
Okay. So the answer is no.
Correct, Your Honor.
From your point of view. Second, assuming that they are applicable, go with me, assuming that they are, assuming arguendo, I'm not asking you to concede, okay, would perjury, number one, obstruction of justice, number two, violate those laws?
No, because you don't have the direct link that is required in Gaffney. There has to be some connection. As this Court said in McLean, Mr. McLean's conduct was an element of the crime, and the Court found that within the narrowest interpretation of the statute, he was covered.
I would say if you're giving this statute a strict construction, Gaffney is way off base. Because as far as I can see, the Court pointed to no laws applicable to his office if you take the position that you have just taken.
No, but what the Court did in Gaffney, Your Honor, is they rejected his rather creative argument that common law larceny wasn't applicable to his position because it wasn't within the four squares of his job duties, when in fact what this Court, in reaction to the legislative change following Kalatis, recognized that the laws applicable to one's position are those that are enumerated within the statute, the bribery, extortion, conflict of interest, that under the legislative change, the federal equivalents of those, as well as any common law crime, as long as there is a connection, if it involves the office or position.
So your position would be the following. I'm just trying to understand your position. Mr. Gaffney had certain responsibilities, correct? They included financial oversight of the water and sewer department, correct?
Correct.
So that your position is, if Mr. Gaffney had robbed a bank, taken the money to buy prescriptions for his ailing wife who couldn't afford the prescriptions, no forfeiture of pension.
Correct, Your Honor.
And the reason is because it is your position that whatever the crime is, has to be committed in connection with the conduct of the official business.
Correct, Your Honor.
So if the clerk magistrate, as he issues a citation or as he conducts a probable cause hearing or as he does something like that, commits a crime, your position is then you forfeit the pension, correct?
Yes, Your Honor. If Mr. Bulger had been called as the clerk of the court to a grand jury proceeding and told to bring the file of Mr. Hines, a juvenile under the custody of the clerk's office, and he misrepresented, he
testified
failed,
there was no such file.
He testified falsely or left something out. Certainly, that perjury has to do with his office or position. But if you stretch the words of the statute in the manner in which the board is suggesting to any crime, this would cover...
It's not any crime. The question is, did the legislature intend to say, in connection with the exercise of his official duties? And my concern is that's not what the legislature said.
Well, they didn't, and they certainly could have, Your Honor. And one of the cases cited by the board in its brief, one of their out-of-jurisdiction cases, Dvorak, is helpful in that regard because the Illinois statute actually speaks to any felony, which is an important distinction because 15.4 applies to any crime. So misdemeanors, you could have a misdemeanor motor vehicle infraction that would result in forfeiture of pension for any elected or appointed officer who raises their hand in the oath, because that is a violation of law. But the Illinois statute speaks to any felony relating to or arising out of or in connection with his service. And that is what the board is asking you to interpret the word involve, to expand it, to expand the reach of pension forfeiture in that manner. And that is for the legislature.
It seems to me that if we agree with you that the oath of office and the Supreme Judicial Court rules are not, quote, laws applicable to the office of a clerk magistrate, that's the end of the case, right?
But even if you don't agree with me, Your Honor, as I said, you need to have the link. The criminal activity has to be somehow connected to the office or position. The board, in their reply brief,
and that would be the involving analysis.
And that would, Your Honor, in their reply brief, which we didn't have an opportunity to respond to, they set out at page 8 the decision out of the Norfolk trial court involving the Marr case, which I agree with the outcome in the case. Certainly, it was a violation of the laws applicable to Mr. Marr's office or position. And they refer, in that case, to the what they refer to as the proximately related but-for case. And that is actually your direct link, this Court's direct link requirement in the Gaffney case. And if you substitute the facts of Mr. Bulger's situation for the hypothetical that the board gives you, or the language that they use from Marr, in Marr they say the criminal act of breaking and entering was both directly and proximately related to Marr's employment and would not have occurred but for his desire to continue in this public employment.
So are you saying then that the misconduct that has, in order for there to be a pension forfeiture, the misconduct has to have been committed during the course of official duty?
No, Your Honor. In the board mischaracterized.
You're not saying that?
No, the board mischaracterized that. Are you referring to the off-duty versus on-duty conduct?
Right.
Your Honor? No, we never contended that. You could have a situation.
Well, then I really don't understand what you've just told me.
Well, I'm trying to respond to
I understand.
if I understand the question correctly.
I thought I was simply summarizing the exchange that you just had with the Chief Justice.
Then I misunderstood, Your Honor. I thought the question was focused on the off-duty versus on-duty, the sort of 9 to 5, if the conduct occurred.
In connection with the exercise of his official duties, and you said, yes, that's what I...
But that's what happened. I assume that's what happened in Gaffney. Mr. Gaffney may have done it outside working hours.
Yeah, it couldn't be that way, because if the clerk magistrate took a bribe at 7 o'clock at night to fix a case while he's off duty, it's clearly involves his office.
And that's my position, Your Honor.
I wasn't talking about temporally what time of night you do it at. It's not a 9 to 5 thing. He took the bribe as clerk magistrate. It's in connection with his official duties. He's not taking the bribe. I mean, you would say if he's taking a bribe or he's giving a bribe to a city official to permit him to have a variance or not to inspect that he's got an unauthorized second apartment in his home, which he's leased out with a kitchen and a bathroom, okay? You would say that's not as clerk magistrate.
Criminal activity unrelated to his office or position would likely result in termination.
And that appears,
does not result in pension forfeiture.
My concern is that appears to be the position of the trial judge in the Boston Municipal Court, And her language is, you don't even look at this because it wasn't done because he was clerk of the juvenile court. That seems to me to be language which is not consistent with this. I'm going to the statute. I'm just going to the words of the statute, which is where I have to go to.
And I would suggest to you, Your Honor, that the decision of the West Roxbury District Court actually carefully analyzed and applied this Court's decision in Gaffney in light of the plain language of the statute, and determined that pension forfeiture did not apply. There was not the direct link required under Gaffney, the connection, if you will, between the criminal activity and the office or position. The result would have been the same in the Bulger case if Mr. Bulger had worked for the gas company. He was there in his private life, and he made a regrettable act out of family loyalty, but that doesn't change the outcome. The job, the position...
That's where I think the matter of the oath and the matter of the code of conduct, which is our rule, takes on a heightened importance. The gas company guy hasn't taken any oath, nor is he subject to this code of conduct, right?
Correct, Your Honor.
So,
But it doesn't, that shows, what I make the point to demonstrate, that the office or position of clerk magistrate was not in any way used to facilitate the crime of perjury. The perjury was a private matter, not anything to do with his public office or position, and that's why...
did he, when he appeared before the grand jury, obviously must have been asked, where do you work? Or where did you work?
He was, Your Honor. That's amply, it's in the record.
So would a grand juror be sitting there and saying, well, this fellow's a clerk magistrate, that's a pretty high position, so he must be telling us the truth?
They may be, Your Honor, but that isn't why he was there. He wasn't there because he was the clerk magistrate, and as we said earlier, had he been there as the clerk magistrate and committed perjury in his official duties, pension forfeiture would certainly apply. That's the reach that was intended under 15-4.
No question about that. No question about that.
But he was there in his private life, and it did not involve the office or position.
It's not the question of whether it involved the office. It's a question whether it involved laws applicable to his office.
Correct, Your Honor. And the laws applicable to the office or position, as I had stated earlier, are those that are clearly defined within the statute in 15-3A, the common law elements that this Court had decided in Gaffney and the federal equivalents. Not any infraction. Again, the result in the Board's interpretation would lead to, for anybody who takes an oath of office, that any violation of the law, however minimal, no distinction between misdemeanor or felony, would result in pension forfeiture. And I think it should be noted. I mean, in Mr. Bulger's case, 32 years of distinguished service, one bad act in his private life that did not involve his office or position. And after this Court had decided the Kalaidis case, the legislature reacted. They've been silent since Gaffney. It's been 10 years.
Well, Gaffney, as I suggest, may be a broader reading than what the legislature intended. Maybe a broader reading.
But it still requires, Your Honor, the direct link.
Because there was a direct link in that case.
And there is no direct link in this case, Your Honor, which is why the trial court decision was correct based on your prior decisions as well as the plain reading of the statute.
Thank you, Mr. Hines.
Thank you, Your Honor.